Prenuptial Agreements in Michigan. Chioini Group, PLLC. Hey everyone, welcome back to our channel. Today, we're diving into a hot topic in family law, prenuptial agreements. Our goal is to provide a high-level overview of prenuptial agreements, including their purpose and the law behind them. Additionally, we will talk about the ever-evolving law in Michigan on prenuptials, and we'll attempt to unpack for you how prenuptials are viewed in the wake of a critical Michigan Court of Appeals case called Allard 3. What are prenuptial agreements? Prenuptial agreements are contracts that allow parties to predetermine their financial fate in the event their marriage ends in a divorce. For many years, attorneys and parties have successfully used prenuptial agreements as a reasonably efficient mechanism of avoiding the expense and acrimony of divorce litigation by resolving and negotiating property settlements and financial matters in advance of the marriage, and arguably, in a more fair and reasonable manner. As divorce rates continue to rise, parties and attorneys have hedged their bets by drafting prenuptial agreements that they believed would best protect their clients and withstand the test of time. Unfortunately, with the continued evolution of this area of law, it is becoming apparent that even the most carefully tailored prenuptial agreement may not be as steadfast as once thought. This video is intended to explain why it is essential to have a skilled attorney assist in drafting and completing a prenuptial agreement. Before doing that, it's important to explain why a prenuptial agreement may be the most important legal document of your lifetime. Why sign a prenuptial agreement? Aside from ensuring an efficient mechanism to avoid an expensive and acrimonious divorce, prenups serve many purposes. 5 reasons to sign a prenuptial. They explicitly define and benchmark what should be considered separate property in the event of a divorce, such as a home that is owned by one partner before the marriage. It may be important for the spouse to ensure that this property remains their separate asset and is not considered part of the marital estate. Another example is a spouse may have an inheritance that they desire to spell out as separate and not marital. Prenuptial agreements can assure fairness in the disposition of the marital estate in the event of a divorce, especially where spouses come into the marriage with widely disproportionate assets and income. Prenuptial agreements can ensure that couples openly and transparently discuss financial situations and clarify exceptions in advance of the marriage. This can be seen as an important aspect of a successful marriage. Prenuptial agreements can protect stepchildren by outlining how assets will be distributed in divorce or death, thus ensuring their inheritance rights are protected. Prenuptial agreements can protect the business interests of one spouse, especially those who operate their business with other family members who may be affected by a divorce of their partner or co-member. The evolution of the law regarding prenuptials. Laws and the interpretation of our laws continue to evolve, making it important to understand its changes when entering into any contract, especially a prenuptial. A prenuptial that is valid and enforceable today may over time be affected by outside factors out of the control of either party. So, the law on prenuptials in Michigan is new and will continue to evolve. We can learn these evolutions from past court cases. The Rinvelt v. Rinvelt case. Michigan law has always provided that a contract relating to property made between persons in contemplation of marriage shall remain in full force after the marriage takes place. However, it was not until the Rinvelt v. Rinvelt case in 1991 that prenuptial agreements were confirmed by our courts to be this way, making a prenuptial agreement to be binding and enforceable in Michigan subsequent to a divorce. The Rinvelt case also stated that prenuptial agreements actually encourage a good marriage. This was an important statement by the court. The court in Rinvelt also established factors that should be reviewed to determine fairness of a prenuptial. These factors were held as the standard of enforceability of such agreements. Factors to be reviewed. 1. Was the agreement obtained through fraud, duress, mistake, or misrepresentation or non-disclosure of material fact? 2. Was the agreement unconscionable when executed? 3. Have the facts and circumstances changed since the agreement was executed to make its enforcement unfair and unreasonable? Following the Rinvelt case, the law on prenuptials in Michigan continued its gradual evolution in a case called Reed. In that case, a prenuptial was challenged based on the last factor laid out in Rinvelt, which related to change of circumstances. More specifically in Reed, the couple came into the marriage with less than $20,000. However, at the time of the divorce, the estate was worth in excess of $5 million, with the prenuptial agreement awarded most to husband. Despite the unfairness, the Court of Appeals found that the prenuptial was valid. The Allard case. Most recently, in a case called Allard v. Allard, 2 days before their wedding, Christine and Earl entered into a prenuptial agreement, which perceivably was viewed as coercive, and the agreement overall appeared unconscionable. This case went up and down from the Court of Appeals twice, ultimately with the court landing on its belief that prenuptials are and should be generally enforceable. However, it also made sure to delineate that there is nothing a couple can do in a prenuptial agreement that can deprive a trial court of its equitable discretion and ability to invade separate assets when necessary to achieve justice. Clearly, the court set out its own very subjective standard, or trapdoor, regarding enforceability. Many believe that it simply laid out an additional foundation for what should be considered at the time a prenuptial agreement is entered. These foundational requirements can likely be met by following certain tips when a prenuptial is negotiated and entered. 5 tips for a valid prenuptial agreement. Assure full and frank disclosure. Both parties must make a full and complete disclosure of all assets and debts, including values. There should not be any vagueness or ambiguity of assets or financial resources of either party, and inquiries should be made. It is often helpful to include balance sheets and tax returns to the agreement itself. Both parties should retain independent representation. In order to avoid the argument that the agreement was obtained through fraud, duress, or mistake, it is vital for each party to have independent counsel to negotiate, review, and sign the prenuptial agreement. This way, each party will have representation to discuss the validity of the agreement, its enforceability, and the legal consequences. Creatively draft the agreement to take into account various circumstances. Though it is impossible to predict what changes of circumstances may occur during a marriage, you can draft language that takes into account various changes. It would be wise for clients and their attorneys to evaluate various scenarios that may evolve over time with your client when drafting the agreement language. Negotiate equitable terms from the beginning. You want to avoid any notion of unconscionability when the agreement is executed. Make sure the other party is free to accept or reject any term to avoid any procedural unconscionability during negotiation and drafting. Further, it is important to also consider substantive unconscionability. Is any term so extreme that it would shock the conscience of a reasonable person? Make sure the client understands the current and potential law on this topic. Even if a prenuptial is set aside later, it still remains an extremely important document that benchmarks what each party had coming into the marriage, which still qualifies as separate property. Many years into the marriage, parties have no record of what they had at inception of the marriage, and this is still a very important aspect of any prenuptial. Lastly, considering the statistics that divorce rates in the next decade will exceed 58%, it seems wise that a prenuptial agreement could be the most important agreement that you make in your lifetime.